Good morning, everyone. Okay, Olivia, did you have anything to start out the morning?
Only that we're currently walking through the list of juveniles and trying to figure out what we can pull, make sure is de-identified, et cetera, with the data practices team. So hopefully folks will have a bit more context surrounding juvenile adjudications and the process by which we see in terms of the registration data. So there was a request made regarding what juveniles were going through as EJJ, as other versions. And so we are trying to pull that data from registration and see what we can find. My understanding so far is that the vast majority of them were simply adjudicated delinquent. But we have not completed the actual spreadsheet yet with that information. We will get it to folks as soon as we can.
Okay, Sheriff Heck, did you have anything to start out today?
I guess the only thing I have is that I'm going to apologize in advance that I have to leave at 10.
Okay, so
all chairs then will be gone at the same point in time, correct? Because Angie is going to be in as soon as possible after 9:30. Then I know that Stacy needs to hop out at 9:50, and Sheriff Heck, you're saying that you need to hop out at what time?
10.
Okay, so actually Angie then will be on. Okay.
Yeah. So Stacy, did you have anything?
I don't have anything, except that I need to apologize in advance, just like the sheriff did, and I need to leave probably around 9:45.
Okay. So we are in the POR requirements subgroup meeting today. And were there areas that you wanted to cover this morning?
So I'll just start off with the extension of the registration period. We looked at, we do have language. I can't remember if this group has looked at the draft language that we have. No, Sherry. So that language has been drafted up by Angie, took a stab at it. And I think that we should probably consider the language as a subgroup and decide whether the language is, something that we're close to, or, take the temperature of this group to see what we want to do with the draft language that we have. I think that's where we are at in the extension, and that's for any conviction resulting in imprisonment restarts a 10-year. So we have language for that. And then the other thing that we haven't talked about a lot, it's come up, but we haven't substantively addressed what to do about it, is collateral consequences. So I'd look to Representative O'Neill on some thoughts about that, because I know that she has mentioned residency restrictions. And I'm unclear. I just don't know. I don't know. I know that I don't know exactly how these collateral consequences work in practice. So from the level 3 in community notification, I understand that from a public standpoint, that if you're on the registry and you're level 3, people have access to your name, and then there would be oftentimes residential restrictions for level 3. I also understand that there are some residency restrictions for anyone on the registry, so there's that. But then what I'm not clear about, and maybe other people have this information, is job applications. If there's a question of, are you a registered sex offender? Or housing applications. Maybe it's for subsidized housing, or maybe it's for just an apartment application. Whether, if that question is on there, and what can we, if we want to limit collateral consequences like this, what can we as a working group do to make recommendations to the legislature on mitigating those? I know that housing and employment are big things that I keep hearing. Is that even, I mean, I don't know if there's been any litigation about those questions being on a housing application or an employment application. I also wonder if that makes it so that that question, and having to answer that question truthfully, if this use of data suddenly becomes non-public because you have to answer the question. Anyways, I'll stop there.
Sherry, did you have your hand up?
Yeah,
Okay.
I did. It's funny. I spent the entire week kind of thinking through this question, Stacy, because I think the collateral consequences they're gravely misunderstood as they are a part of, from an employment perspective. And it's funny, I brought a background here from a real live situation that I had in my work group that I wasn't sure would come up today, but ultimately ban the box prevents that type of question in the state of Minnesota, and most states for that matter, where asking that on a job application. Now, in the leveled systems, there are roles that are clearly outlined as kind of off limits, but being an employer and being an employer in many industries in many states in this country, ban the box, we don't ask, and for the most part, we ask, are you able to work in this country, right? And so are you, and that's really the extent of it. Background check requirements are usually filtered and prioritized by the employer themselves. So, and that's where ban the box came into effect. So ban the box then has a secondary component to it called fair chance. And so what I think I said maybe a couple meetings ago was that if employers are really evaluating fair chance responsibility, they're taking a look at the specific job, the requirements of the job, and then the crime committed. So I'm not gonna give it to you, but I have a background check here that had an individual who came through. And I really wish that I could show you this so you can see what I have here. You can't, but right here, it shows National Sex Offender Database search, no records found, right? So there are none. However, there's 5 counts of felony possession of pornographic work involving minors, real life situation, right? So when I did my, and I would ask for this group to internalize this on this call only. I understand it's recorded, but there's a real person attached to this. When I looked at the 5 counts, he's 24 now, a 21-year-old exchanged pornographic material with his girlfriend, who at the time was 17. There you have it. So he is in a very technical program, all head and shoulders above his peers. We go to hire him. He has 5 counts felony activity in all of these categories. So this is real, is not on the registry. But as I said, like 5 times over, his crime is public. And so when we talked to him, the question was, we broke up, she was young. I understand all those things. So Stacey, this is exactly what we're talking about. The registry is not playing a role in this at all because he's not on the registry. It is a crime that's public, and the non-consensual dissemination of private sexual images is exactly what happened. My guess is, if I'm doing the math on this and looking at it, he's a level 1 in our system, but we would not know that, nor does it pick up on the registry at all. The crime picks up. So it's my job now as an employer to determine, He's a mid-shift technician application for a reconditioning center that is not customer facing. So if I'm doing my fair chance work, I'm not going to bounce him unilaterally on felony. I'm going to look and say, who's in this facility, not public, what hours, who's there, what has he done? I can get 2 character references, rehabilitative references and statements, and the school is willing to say, good kid. Am I going to hire him? Most likely. So I want you to see, I want to suggest that if we look at the very legislative parameters that we're supposed to comply with now, this shouldn't be an issue. Do most employers go felony? No, they do. And so I just wanted to raise it, and I'm glad that you brought it up, because I don't know. I think it's an application for employers to understand what is their responsibility in this type of scenario versus the recidivism and expectations are that it's just going to run rampant. This has no more likelihood of occurring in our work group than any other crime. So I don't know, Stacey, if it answers the question, but nowhere in the state of Minnesota do we ask that on an application, nor should you. And if you ask, have you been convicted of a crime? Those are what they call the truth serum, you know, because then they catch you on lying. Because if you said, nope, haven't, because you're afraid, now we've got you on a lie. And those should be removed, and employers should not be using them. So that's, I mean, I don't know if it adds to what you're asking about, but that's what when I think about it, I think we have the proper protections, not the great application of it.
Okay. Nate.
Thanks. Yeah, I just wanted to know if there was any interest in discussing the mandatory minimum. I did do a little bit of legislative research, like a little bit of just very, very, very preliminary legislative history on that, if anybody's interested in discussing that.
Should we move that to after this first discussion of Stacey's?
Yeah, I thought we were still on setting the agenda. That's why I brought it up.
Yep.
So
exactly.
Yeah.
Good. Okay. Sheriff Heck.
As Sherry kind of aptly described, I think that the question about collateral consequences being on the registry versus consequences for having a conviction are things that we have to kind of parse out pretty carefully, because even if the registry were to go away, as mentioned before, these criminal history convictions are still out there and they are available to the public. And that is most likely, at least in Minnesota, from my understanding of the access to the registry, where some of these collateral consequences are stemming from, because again, this is private information. And the other caution that I'll throw out there is, as we get questions every once in a while about curious members of the public that go online and think that they have a sense of how many sex offenders are in their area. And it's, you know, for those of us that work with this know that, well, what you find online is not accurate, especially in Minnesota, because there's these companies out there that will crawl through all public data available, and they'll try to put together and sell people a product to let them know that, hey, we know where all the sex offenders are in your area. And a lot of times we've encountered people calling in saying that, hey, you know, Johnny down the street from me on the internet says they're a sex offender, when in reality they're not. It's data they've misinterpreted or they got a name wrong. So even when employers do these background checks with even well-intentioned companies that are out there trying to find background information on candidates, they can make mistakes and they can get that information wrong.
And just to kind of clarify the distinction, I think what Sherry was talking about is an employment background based on really criminal history and non-access to the registry. But I think what Angie had brought up were those statutory consequences that specifically say, you, Sherry, if you were hiring for a position in horse racing or in human services, Department of Human Services, you would not have any flexibility in those situations. because there is some way to have access to the registry. So there is a distinction between those that are statutorily allowed and those that are simply based on, as you said, Sherry, the criminal history check.
I'm sorry, can you explain that again, Mark?
That there are, Angie provided a list of statutory things that preclude somebody from being employed in certain areas or give access to the registry. And the good example I think people have brought up was the horse racing one, but there's also teaching, there's Department of Human Services, and then there are what would truly be called collateral consequences, where people are on the registry and those residency restrictions are imposed. And residency restrictions are not limited to public level 3s. Residency restrictions also apply to people on the registry. And that's where law enforcement gets that information to enforce a residency restriction. So again, it's a collateral consequence. It's something that comes from being on the registry. And as Representative O'Neill said, what would magically go away if that access to the registry wasn't allowed for those purposes? And yes, in many cases, residencies, many of these residency restriction ordinances would be affected, plus bars on employment in specified areas within the statutory exclusions. So, Stacy.
Sure. So I'm just making my ignorance completely known. So Sherry, thanks for all that explanation. It was really helpful. So I understand the difference between a felony, or a criminal background check that reveals all kinds of stuff, and then a question about the registry. So am I understanding you correctly that in Minnesota, if I have a job application, I am not allowed to ask if someone is a registered predatory offender? And are you saying that that doesn't happen in the state?
You are not allowed. Can you hear me?
Yeah.
Yes.
Yeah, we are not allowed to ask, and again, I'll tell you the difference between good HR and bad HR. I mean, I see it all the time, but at the same time, you are absolutely not allowed to ask criminal discussion points in advance of a background check. It is a really bad practice for biased interviewing, and there's a whole component of race and ethnicity to get into that. So we train very specifically. Ban the box absolutely prevents you from asking questions about someone's criminal history, the background check in advance, right? Because in advance, what happens is you shut the candidate down in your mind before you even, and you can do that on biased interview processes for ethnicity and race just by asking that question to begin with. So we train definitely not to do it, but at the same time, ban the box prevents you from doing it. It's not on the application, as well as, very effective organizations, quite frankly, look at the crime as and if you've done ban the box or last chance or fair chance training, you would understand that there are certain positions that don't yield an increased risk and should be, you should absolutely consider. So yes, you're right. We do not ask. It should not be on any applications. And I've called my counterparts at Best Buy and Target. I mean, we are a massive employment state when you think about what we do here, specifically in the Twin Cities, but we are all very aware of that. It's how does it play out in process? I only do an MVR because I am a driving company and people move our cars, so I have to know that. And I do county criminal, national criminal. That's what I do. If you're a 3, you will come up on the sex offender database. That will, because that's public and there's a nationwide component to that. Other than that, I see the felony.
Okay.
That's it.
That's good to know. So, so we've got collateral consequences, both statutory and there's the housing issue too. We've got the extension language that we should consider. We've got Nate's suggestion on the mandatory minimum. I would be interested in hearing and learning about that, Nate. So thanks for bringing that up. Anything else? No. So, well, maybe in the interest of considering proposed language, we should have that. Do we want to do that? Look at the extension, the 10-year extension on any conviction resulting in imprisonment? Does that feel like a worthwhile? Yes. Okay, I get one thumbs up. All right, good. Two. I don't know, Mark or Olivia, if you have that at your fingertips. If you don't, I can dig around and find it.
That's Angie's language?
Yeah.
Okay. Yeah, I have it here.
Okay.
Do you see that registration period?
Yep. So what she did is, so we're not seeing any strike throughs here, which would be helpful to see, but we can get that eventually, but I'm thinking that there's probably some strike throughs. But what she did most notably in section 3, or I'm sorry, section C, is to list out she put in the specific subdivisions that were from list 2, which is list 2 is, do we have a statutory reference for that? 3, I always forget the.
Yeah.
Are we talking about the crimes against the person?
Yeah, I'm trying to get the
Which is
statutory. Oh,
243.
609. What? Go ahead.
So with regards to in the registration chapters, it's in 243.167.
Yes, that's right. That's right. So just in terms of where the inspiration has come from, what she did, instead of any conviction resulting in imprisonment, she listed out the specific statutory references to crimes that are in 243.167, which are those crimes against the person. And then she also added a violation of a order for protection and terroristic threats. So it would be those, oh, good. Those crimes, I believe, that would trigger the 10-year restart wherever that person is in their registration time commitment. So I think we should have just a discussion about whether these crimes are, I think one of the issues is, are these crimes, is this enough? You know, if we're going to take away any conviction resulting in imprisonment, does the group feel like the crimes against the person plus order for protection violation and terroristic threats, does that feel like that's, as a policy matter, we want significant crimes like this, crimes against the person, to re-trigger the registration obligation? Or do we want to stick with what we have, which is anything will get you another 10 years? Anything resulting in imprisonment will get you another 10 years.
Sherry.
Yeah, Stacey, I think the only thing we didn't come to terms with this possession of a firearm, the unlawful possession, I felt that was still necessary. And again, I think this is where we did the survey or whatever we called that little, whatever you sent out. And I know it was 3 of us that felt differently. And I would also suggest that failure to register is not on here, or is that separate?
That's separate.
Yeah.
That's got its own,
Okay.
that's got its own provision.
Yeah. I mean, I think
Yep.
that the firearm one is missing, when I know we talked quite a bit about that. And when I read through the level 3s that had a weapon and or not in Hennepin. So I think that was the only discussion point that we had. Again, for those who 3 out of 11 still felt that any criminality was still a retrigger and 11 didn't. So I understand there was a minority and a majority report we would look at. But at the same time, I would question whether we should have the firearm part added to this.
Katrina.
Thanks, Mark. Good morning, everyone. I'm just hopeful somebody can give an explanation of the thought process around adding terroristic threats specifically. I'm just wondering if I missed something in the conversation.
Brian.
I guess I can't add to Katrina's question necessarily. I've always kind of wondered why that wasn't a part of maybe the list 2 crimes. Of see people come in for convictions for terroristic threats that often involved other assaults and things like that, and the conviction was terroristic threats that seem to be concerning, you know, in a lot of cases. So I'm in favor of adding that. The felon in possession of a firearm, for me, I think what Sherry's talking about in terms of people, she went in, what was it, level 3s, or people that are using weapons during the course of the crime. In Minnesota, you're going to get charged with a 2nd degree assault in those situations too. So I'm talking more about just possession of a firearm, not in the use even of a crime or that kind of thing. But in terms of Stacy's just general question, I agree that there should be some, whether this list is comprehensive enough or not, we can still discuss, but I'm in favor of limiting it from any crime that would re-trigger the registration period to some subset of these more person-related crimes.
And Stacy.
Yeah, so I would just echo what Brian says. I'm just looking at the statute on what Nate has pointed out is formerly known as terroristic threats. It's 609713, as he puts in the chat, and I just pulled it up, threats of violence. And I too am comfortable with this being included in something that would re-trigger. Katrina, if you have specific concerns about it, you know, it'd be great to hear. I think as a group, I don't remember exactly the discussion, but when we were thinking through, you know, what substantively warrants another 10 years or added 10 years onto the registry, we're thinking about protecting people. We're thinking, you know, as opposed to maybe a disorderly conduct that if you serve time, that would get you, you know, the additional 10 years. That there's a difference between crimes that, you know, are, you know, really directed at people and that are violent, as opposed to other crimes that may not be directly, you know, at someone and that don't involve violence. So welcome, I welcome your thoughts, and if you have concerns, let's hear them.
No, I was just, I appreciate that, Stacy. I was just trying to make sure I hadn't missed something in the conversation. The fact that it's a re-trigger is just something I thought maybe I missed in the conversation. And so just was hopeful to get the context. And I think what's been when shared this morning is helpful for me. I think specifically for kids, it manifests a little bit different, but we're talking about a re-trigger. And so I think that's a little bit different of a conversation when we're specifically talking about this in a more tailored way. And so I just appreciate the explanation. It was helpful for me.
And is it my understanding that terroristic threats isn't actually on this list that Angie provided, right? I don't see it, so.
To be added.
It's threats of violence now, Mark. It's down a little bit.
Oh, okay.
But is it in, sorry to interrupt, is it in the statutory language up there? Oh, there it is. Okay.
Okay. Yeah. We used a different term before, so it is threats of violence is the correct one now. Sheriff Heck.
Well, first, I realize I'm in the minority, and I've said this before, and I'll mention it one more time, that I'd be concerned about any criminality. But moving on to this list in specific, I do still think that there are a number of things on this list that have been missed. I see that, you know, we're including burglary in the first degree. I'm curious why we're excluding any other levels of burglary. When I look at a statute I'm a lot more familiar with, that is the crimes of violence for purposes of possessing firearms. That includes first and second degree burglary. And I know it's much more common, at least in my experience. It's pretty uncommon in my experience to get a first degree burglary charge out of a case that we're working. I look at some other things, theft involving a firearm, riot, drive-by shooting. I know it's arson on here. Sign 561. Arson's not on here. Riot, harassment. You know, I think that there's a number of pretty serious offenses that are not included on this list. Yeah, even simple robbery versus aggravated robbery. I'm not sure why we'd want to specify that it has to be aggravated first degree robbery. I think even simple robbery to me is a pretty serious offense, an indication that the person has not been rehabilitated at that point.
And Sherry.
Well, I had one question, and I know Stacy, you're gonna like want to do a backflip out the window when I ask this question, but would it be more, well, can we decide maybe off list one, which ones don't belong versus going to list two and scrapping all of list one? Because that was my whole argument on the firearm question, is how one obtains the firearm and for what reason. I understand the duck hunter who doesn't realize he has an unregistered rifle in his basement. I get that. But I felt like, are we absolutely sure that everyone off list one doesn't belong on, with the exception of? So we took a kind of, let's scrap this and move to this. I felt like we needed to maybe go back one more time over list one, if we're going to say that, right? Because we said all, we went from all to person, but to person plus maybe. Just one more person plus review.
No. Now, do you mean list two?
Yes.
List? Okay.
Sorry.
Okay.
Sorry.
So just to be clear, this list includes all of list two, except for that possession of a firearm. That's the only one that was excluded.
And then the other crimes that Sheriff Heck is talking about, and he can probably elaborate better than I can.
And those are in addition to list two.
Yeah.
Clarify.
And then my other question for hand raise was kidnapping and false imprisonment. Where are they? They're elsewhere, correct?
They are already a registration offense, so they would be redundant. If you get convicted of false imprisonment or kidnapping, you would have to register anyway. It's the same thing for excluding
I understand.
criminal sexual conduct. Yeah. Okay. Stacy.
Yeah, I was going to answer Sheriff's question, and I just want to acknowledge what Sheriff Heck said. I totally get that, right? There's a criminality aspect. If someone's convicted of arson, it's like, have they been rehabilitated? I guess the issue is, the concern I have is that this is a predatory offender registry. And so we're wanting to track folks who have that predatory element. And the ones that we have looked at here, this first draft of revising the extension these are more in line with that predatory nature. I get what you're saying about the criminality, and that's, gonna maybe bump up that risk level. And I would look to Brian maybe to talk about, how that risk level changes. But I hope that we could stay focused on actual predatory offenses as opposed to any offense.
Sheriff Heck.
And not to be the contrarian, I guess the difficulty I have when you talk about classifying things as a predatory offense is a lot of times that comes down to the motivation behind why the person committed a crime. If I commit a burglary on your home because I simply want to go in and I want to steal your television, versus if I commit a burglary on your home because I want to go in there and to continue to terrorize you, or perhaps I'm going in there because I wanted to abduct someone and sexually assault them and there just wasn't anybody home, I could very well end up with the same charge under the statute, even though my motivation was different. Same with arson. If I'm burning down my shed because I want the insurance money versus if I'm burning down my shed because I want to terrorize somebody, it very well could be the same charge. So it's difficult in my estimation to look at a list of statutes and say, well, this one is always going to be a predatory offense versus this one isn't, because I think a lot of it comes down to motivation. And just one other point to the firearms issue, as I mentioned, the main reason that people are excluded from possessing firearms and would therefore be subject to the criminal consequences for possessing them is because they've committed the crimes that are referenced in the 624 statute. There's a few other reasons you can have your firearms rights removed, but by and large, most people that are ineligible to possess firearms are ineligible because they've committed a crime of violence.
Representative O'Neill.
Thank you. So I wanted to point out something too. In my work with the test all rape kits legislation that I did, that was prior to changing the criminal sexual conduct statutes, and many of you were in that working group. One thing that we uncovered in the work of the testing all the rape kits is that there is a nexus between burglary and rape, and they could see it in the DNA. When I talked to the BCA, they were saying, we're getting hits on burglary cases and rape cases, same person. So I couldn't agree more with Sheriff Heck that anytime someone is invading someone else's home, that's predatory behavior. That is the essence of predatory behavior. So I believe, and really anything committed with a weapon, dangerous weapon, is predatory, violent. I also completely disagree with eliminating kidnapping. And I think Patty Wetterling had even said the same thing, that she believed kidnapping should absolutely remain on. So I think the only one that we had discussed at any great length of removing was possibly false imprisonment because of how it's used typically by prosecutors. So I'm willing to have that conversation, but I don't think any of these other things are going to fly very far at the legislature, quite frankly. There just isn't the basis to do that.
Okay. And just to clarify, Representative O'Neill, this is not the list of registration offenses. This is the list of retriggering. And the only reason kidnapping and false imprisonment were removed by Angie is because they're redundant. They're already registration offenses, so they're not needed on this list to retrigger. It was just an oversight originally. Stacy.
I would defer to Representative O'Neill. Maybe she has a follow-up on what she just said. But yeah, this is very different than, we're not taking kidnapping off that, or we're not proposing that. And false imprisonment isn't off, it's just recategorized. So that stays. This is a completely different issue. This is the retrigger for 10 years on subdivision 6, 6C. This isn't who registers in the first place. This is if you're on the registry and these things happen, then you get another 10 years when you get out of prison. From the time you get out of prison. So I would defer to you. I do have a couple of comments. I just wanted to follow up on what Sheriff Heck said and also what Representative O'Neill said about the burglary issue.
Representative O'Neill.
Thank you. No, I understand that. So I think so we probably need to look at this, like was said earlier, at the list of, okay, let me back this up. So you're trying to use this list as the retriggering, but you're saying that kidnapping, false imprisonment are already retriggers for extending past 10 years or another 10 years. Is that what you're trying to say?
It would get you, yes, another 10 years, and it may get you a lifetime. I'd have to look.
Right. Okay. So, so this conversation is what to take off of the list that would retrigger. And the one conversation we've had repeatedly through this whole thing for 2 months is false imprisonment. Right. I mean, that's the main thing that we wanted to remove because it has a nexus with domestic violence that isn't considered as often predatory or something was the conversation. Not that I necessarily agree with it, but that was the conversation. So, I mean, this is the list of the crimes of violence, right? And so if these obviously have to extend, maybe we need to switch the conversation of other things, as in if you get a DWI, we had that conversation, or DUI. So if you are still embroiled in your addiction, you have a high propensity of reoffense of other criminality. Have those conversations. So we can have those conversations about possibly false imprisonment, but I definitely would not, as Sheriff Heck said, anytime you're invading someone's home, whether it's to burn it down or to commit burglary or whatever, I think those are definitely predatory type things, but maybe we need to look at a different list in a different way.
Stacy.
Yeah, so I just put in the statutory language in the chat about what we're talking about. And this is, to be clear, just making sure and we have it up. So this is for the registration period. And so the false imprisonment and dealing with that is a separate issue that the crimes subgroup has been talking about, and in terms of whether a conviction is required for false imprisonment or not. So that's a different issue. I just want to get back to the burglary thing, and I do think maybe we look at what Sherry said, that we should look at what is not included as opposed to is. There's so many, I guess we started with is, and now we can maybe shift to not. But, I think it's a fair point on the burglary thing. As Sheriff Heck noted, personally, if someone came into my house and tried to rob, and tried to come in and take stuff, I would feel very much like that feels predatory. I think, he raises a good point about what was the intent. Was the intent to steal the TV, or was the intent to come in, rape someone, and, no one was home. And so, he took a bunch of stuff. And that, I think, illustrates one of the huge problems with this registry is that it doesn't take into account anything other than whether you're convicted or something or not. And there's no ability to have a judge determine these facts as this is charged and the conviction on which it's based do not warrant registration. So I think it just points out the real trouble with the registry is that there is no analysis of any factual basis. It's a strict liability in that if you are convicted of, in this case, convicted, but in the others, the other piece of the registration in the first instance is strict liability if you were charged or convicted, with the exception, hopefully, of false imprisonment. So anyway, I would just add that. I think these are all really good comments. I think maybe looking at what wouldn't be included is a fair way to go, and might be more efficient.
And that's something that Angie can probably address, because this was just, again, I think her first
This is the first cut.
draft of a
Mhm.
concept. Brian,
Just along those lines too, in terms of motivation, I've seen second degree burglary most of the time is, breaking into an unoccupied residence to steal items for drug addiction, those kinds of things. Still for sure invasive and, wouldn't want that to happen to me. But I also have seen second degree burglary where the guy breaks in, steals underwear for masturbatory purposes, like a fetish burglary, as we call them in the business, where maybe it would be more concerning. There's evidence of paraphilic behavior and that kind of thing. So again, no way to decipher motivation at this point is problematic. And then just with the false imprisonment thing, maybe more clarification again. That the false imprisonment language, I think, is for somebody who's not registered at all right now and then commits a domestic assault, is charged with false imprisonment. Would that person need to even be on the registry? Is a separate debate then. If a guy's got a criminal sexual conduct third degree, and as it stands now, is now charged with false imprisonment 6 years later and convicted of something, he's going to have lifetime registration, that whole thing. So it's not, that's where the redundancy piece comes in from this current discussion, I think. If that helps, I don't know.
Sherry. Oh, you're on mute.
Brian, that's hugely helpful. I mean, I think the intent and the impact and those things are really, really important. I had, as we keep going around these things, I had to ask a question on time stamping all of this. Mark, have we determined that we're going to extend our time together? Or are we going to, because today would be mid-November, which is when, so I'm just trying to put this in a box and understand, one, is anybody willing to have a secondary meeting this week? Are we running out of time? Can we meet in person? Again, I know I've asked that. I know how some of you feel. I feel like we have to get through more of this real time. And every week I feel like I'm letting you guys all down, or we're all trying to come and go in a million directions. And yet we have work to do. Where are we on the timing of this, Mark? So we can either put more time on the calendar or, is that possible?
Yeah, and at this point, this is our last scheduled
Right.
Scheduled meetings for the subgroups, but that doesn't mean that they can't be extended.
Yeah, because are we all, I don't think any of us is willing to put our name on any recommendation at this point. And I think as Representative O'Neill has said, she wants consensus in some degrees in her world from law enforcement, as well as all of the branches that exist here. I just felt like when I saw this, I said, oh, we're down to the wire. So how much more time are we willing, or can we all make for making these 5 or 6 decisions that I think are still open for us?
So do you see the calendar now?
Thank you.
So that the full working group is scheduled now for next Tuesday, November 23rd. There aren't any more subgroups scheduled except for this afternoon and tomorrow morning. But those additional subgroups, or maybe even mini subgroups, could be added to the calendar. So keep that in mind. Is that decision? I think we just have Sheriff Heck here as the only chair at this point. So, but that could be a decision made. It could also be part of the discussion today. I think it's very clear on this proposal on the extension that definitely does need more work to go into it, and whether that's a subgroup or a select subgroup to work on that language is probably a good question. Nate.
So I have a bright idea that maybe a terrible one, but I mean, it occurs to me that I thought it was an interesting comment about, there's no distinction being made here between different crimes. And it occurs to me that since the triggering event is a conviction, and since a conviction requires an appearance before a judge, can we ask the judge to make a finding or not make a finding, depending on how you structure it, to say, hey, look, if this crime was committed under whatever circumstances we want to say are the concerning circumstances to us, then it's an extension. And if this new crime wasn't committed under those circumstances, then it's not an extension. And maybe we could make it just any crime that results in imprisonment if the judge finds X. It's just a thought, and then we wouldn't even have to change the list necessarily. Just require an additional layer of judicial fact finding at the time of the conviction on the new offense, since they're going to be in front of a judge anyway. Just a thought.
Representative O'Neill.
I had another comment, but Nate, that is brilliant. And that could so easily be done legislatively. And I was working on a piece of legislation with that type of language very recently. And it had to do with, if the judge finds that person is still a danger to others. It's very simple, because that's the whole point of the predatory offender registry. So that, I think that's actually very simplistic, and that gets to a lot of things we've discussed for the past 2 months. I really like that option. The other thing I was going to say about these dates is that whoever's sending out the invitation for the date of the 23rd, I still have it in my calendar of the 24th, and I was waiting for someone to send out the corrected calendar invite, and that hasn't happened yet. So I'm not sure who does that, but if you could send that out, because I can't physically change the one on the 24th and move it to the 23rd. So, and the other thing I would say is that I only take 1 week vacation a year. That's it. And I always get nipped at the ends of it. And unfortunately, the 15th is the one and only week I'm taking off with my fiance, the senator. So I am not available on the 15th. If we could pick a day the week before or the week after, I am more than happy to do that. I have absolutely committed to taking a little step back, having a break.
Yeah, and and I'll let Sheriff Heck make that decision. We are confirmed for Tuesday, the 23rd, and we can send out that change right now.
Okay.
If that is confirmed. Is that it, Sheriff Heck?
I was just going to suggest that while I do understand Sherry's point, and definitely the point of the time ticking away, perhaps that's a topic that we could address on Monday at the chair's meeting and come up with some alternative dates to try to keep this work going. My suggestion might be that we recognize at the point that yes, timing is an issue, that the chairs will address the timing and need for additional meetings on Monday, and that we use the time in this subgroup to talk about what some alternatives might be to what's been presented, so that we can have some work done on these alternatives and bring them back to the group in maybe one more subgroup meeting once we kind of put a polish on them.
Okay, Sherry.
I wasn't clear when I see possible other dates. Are those for full working group dates? That was
Yes,
my, yes, okay. And then Nate, I like that suggestion as well, just to clarify what Representative O'Neill said. So would it go back to a broader list, but then only the judge would rule on the relationship between the crime and the extension in all cases?
Okay.
So,
Yep.
so I'm saying it would be as if the language we've had in the past, or the broader list that we've had in the past, would apply if a judge ruled that there was a relationship between the conviction and its motivation. If I'm hearing it correctly, because then you're not narrowing anything, you're making a determination based on why you did what you did, or am I hearing it wrong?
Nate, just to respond to that.
I guess what I would suggest is, so I mean, one question would be, is this a finding that the judge has to make, or is this something that clicks in if the judge doesn't make a pro-defendant finding, let's say? And I think if you were going to keep the whole list, which I think is rational, then it would also be rational to require the judge to make an affirmative finding that there is some kind of nexus between this new crime and whatever the standard is, that this is somehow, I mean, there's no standard really in the law right now, right? It's just, if you commit this crime, you're on this list, which we're calling predatory. So, I mean, if there was some kind of nexus found between the new crime and being predatory, I guess, for lack of a better term, then I would say, yeah, why not keep the whole list? Why not just say any crime? I mean, if it's any crime and there's a predatory nexus, then extend.
Representative O'Neill.
Thank you. I was going to point you in the direction of the work and the language, which is the work I did on the Restorative Justice Act for the Veterans Restorative Justice Act. And in that, when the veteran has completed, it's sort of like a veterans court, but it's not veterans court. It's a diversion program, and they come back before the judge, and the judge has to evaluate different factors to find out if that person is in fact safe to be back in society. And then if they find they've been compliant with various things and that they are no longer a danger to the public, then they can dismiss the charges. But in this case, it would be, so I'm just pointing in a direction of some language that's already been put into the statute that the judge can look at, and different factors to determine whether or not that person is in fact a risk to society. I think that's a really great place to start if you want to look at something specific. It also includes a victim's impact statement. And so for the original victim, it looks at, have they been compliant with probation and treatment and all that kind of stuff. So I don't know how in depth you need to go, but there is language there already that we just put into statute in the last year or so. And probably Nate knows it because he probably had to evaluate it, I'm guessing, for his work, but just somewhere to look.
Yeah. And then Angie, I'm not sure how much you heard on this, but that original draft language that you provided, which was only a first draft of crimes against the person plus some additional things. And the discussion went into expanding that list even more. And then Nate came up with the idea that, well, maybe not distill it down to specific statutes, but go back to the original, anything but require a judicial determination. So,
yeah, I mean, I personally think it's a bad idea to get the judiciary involved in this. I think we should pick whether it's leave it as it is or narrow it to crimes against the person plus whatever else we think is appropriate. I just think we need clear guidance. And I think you get into the whole issue of differences, judges doing different things, attorney representation, and all kinds of equity issues. I think the statute should be set, however it is that we want to recommend. I just think there's going to be all kinds of I don't like the idea of leaving it. And it's like, you know, prosecutors and defense attorneys are going to have to remember to do that every time. And then the BCA has to find a way of tracking what all's happening in the courts. I mean, right now, they get a conviction, they know that has, you know, they get a conviction, they know the person's incarcerated, they easily get that information and they extend it. So I just think it's really going to muck things up if we do it that the way with the courts. Yeah, I just think we should just get a clear list of what we think is appropriate from a crime standpoint. That's my view anyway.
Okay. Anything, so at this point, there's still probably subgroup business to you to address this. We had that list of possible dates that, and they're not, it's not a limitation on those dates. It could, additional dates on those Mondays and Tuesdays could also be used for subgroup work. But I think Sheriff Heck said that they'd address that on Monday's meeting, that the chairs would address that after considering how much detailed work has to at least go into this specific issue.
I think that makes sense. And Representative O'Neill, what was there was a date that you were not available. And I want to make sure when we do the full group meetings for sure that you're there.
It's the 15th of December.
Yep, so thank you. Yes, so I'm going on the 10th up to Bemidji and tour the BCA up there. And then the week, so I mean, I could do a remote meeting because I think the tour is just in the morning, but we typically meet in the morning.
Yep.
And then the 13th through the 17th, I'm going to be hopefully off the grid.
Okay.
I'm going to go hopefully
so
hiking through great parks or something.
Yeah, just so we have that, because I mean, I think especially at this point in the process, it's really important to have the legislators' input.
So that issue kind of the calendar, and if anybody else has other concerns about the calendar, let us know so that the chairs can take that into account when they address the calendar issues. But I am confirming that the next whole group meeting will be on Tuesday, November 23rd, and I will send that change to the calendar. Now, also on the agenda, Nate brought up the issue of the mandatory minimums on false imprisonment convictions. Did you want to address that in more detail, Nate?
Yeah, just to share what I dug up on legislative history, and this wasn't really much digging. This is just a document that was sent to me by the Legislative Reference Library called Senate Briefly. I haven't listened to any of the recordings or anything like that, but I thought there was some interesting information here. The bill in question was from this 2000 session, and this document's called Senate Briefly, and it describes Senate File 2396. There's a group known as the Katie Poyer Abduction Task Force reported to the Crime Prevention Committee that current laws don't go far enough in tracking convicted sex offenders, putting the public at unnecessary risk. So there were a number of recommendations that came out of that task force including increasing the maximum criminal penalty for violating the predatory offender registration law and providing for minimum sentences for non-compliant violations. So that's that. So basically, Senate File 2396 was a vehicle for this task force. So it became the let's see, Katie Poyer bill. There was a, so here's the Katie Poyer bill, which there was a discussion about the mandatory minimum. I'm trying to find it. This is a pretty long document. It covers basically the entire session. But one of my predecessors actually testified in front of the committee to talk about the impact of the mandatory minimum penalty. And I'm not seeing that right now, but oh, here it is. Deb Daly testified that there would be significant impact at a hearing in February, and that as a result of that, the committee amended it to what we have now, which is a 1-year mandatory minimum for the first. It was 2 years as it was originally introduced, 2-year mandatory minimum, and it was a hard mandatory, which is just not a real term, but that's just what I call a mandatory that there are no legislative exceptions for. And they made it a soft mandatory, which meant that the judge could depart from that mandatory minimum. And it was a 1-year mandatory minimum. I think it was still at that time a hard mandatory minimum for 2 years for repeat offenses. But that's since become a soft mandatory as well. So that was adopted. And then the other thing I wanted to point out for the legislative history was that 30% statistic was in this document. Let me see if I can find it here. It says that under the bill, Senator Amber Reichgott-Young, the bill's author, said that under the bill, sex offenders are required to register all residents and property addresses and vehicles, and the BCA is required to verify sex offenders' addresses 4 times a year, and failure to comply will result in a statutory minimum felony sentence of 1 year and a day, up to 5 years, and a $10,000 fine. Stephanie Good of the BCA said that Minnesota has a 30% non-compliance rate for sex offender registration for 9,800 offenders under the system. So I take it to mean that there was a 70% compliance rate before the felony and before the mandatory minimum. So I guess that leaves open the question, you know, what would the compliance rate have been if it were just, I mean, assuming that there were a lot of changes made in 2000, so we don't necessarily know what, you know, it wasn't a controlled experiment, if you will, but if we're to assume that the increase in penalties is what caused the increase in compliance, I guess we still don't know how much was caused by creating the felony offense and how much was caused by that addition of creating the mandatory minimum offense. You know, I guess given the high departure rate, and the other thing is given the statistics on so I guess I wasn't here when we talked about the racial composition of the predatory offender registry, but if it is true that there are more minorities who are convicted of this offense than are represented on the registry itself, I guess there might be some. It might give us pause, I guess is all I would say on that. So yeah, that's really all I had to say, Mark, unless anybody has questions.
Well, thank you for bringing this up, Nate, because we were going to tell folks that we don't have the data on our non-compliance from 2000, 1999. We've had numerous IT changes since that time, and the furthest that we could reliably go back is just a few years. We do want to note, though, that our initial PowerPoint that we presented to the group, the vast majority of registrants are white males, well and above. So if folks would like that data again, we're happy to resend that out for reference.
Representative O'Neill.
Thanks. So I think something else that happened in Katie's Law, if I remember correctly from the BCA's presentation, is that we dealt with homelessness differently. We had, I mean, think about how many homeless offenders are on the POR. And I believe they changed the requirement that they had to come in. I'm not exactly sure the whole change, but it seemed like that was a pretty large change in the compliance rate, is because now you have homeless people that just couldn't comply because they were in the streets or on someone's couch. Now would actually come into the station, the police station, to check in. So I think there's a compilation of different things of why the compliance got to be so much higher. And I know when I listened to the hearing that Rich Stanek was the chair, and I believe it was now Senator Anderson, then Representative Anderson asked the question about compliance, and it was a Minneapolis police officer that said 36% were compliant. But I'm sure that had to be then just for the city of Minneapolis, which has its own set of issues. But I think it's important. I don't know if Olivia wants to reiterate what she said about Katie's Law and the change specifically to the homeless population, because that seemed to be a big problem with compliance, was their inability to be compliant.
2000. So what we're looking at here is actually a large cluster of changes for about 5 to 6 years. So you're looking at Katie's Law, you're looking at a couple years down the line, you're also looking at homeless offenders having their own process. You're also looking at actual registration changes. So in terms of the content that we're collecting, we are also looking at, I believe, here we go. Yes, so the list of information, there was also lifetime registration that was added in certain situations. Then you have 243.167 added. So there is a rather large compilation of changes that were made inside and outside of Katie's Law over the course of that 6-7 year span. So there are a number of changes in that whole time frame that could impact or could change things. So I'm sorry I can't be more definitive, and we can't be 100% sure which led to which, but there were a significant number of changes. And I can resend this PowerPoint again to folks just to have, if folks would like that.
And Drew Shadeen was it?
Oh, and Drew Shadeen changes as well. So I believe that was
2005.
2005, yes. She went missing in November of 2003, and then there were discussions in 2004 and 2005. So.
And Nate, on your comment about the disparities on that, we did get those statistics on registration. The disparity for those who are subject to registration are definitely not as large as it is for the entire criminal justice system. But as you noted in the information you provided, Nate, on the disparity on convictions for failure to register, that's a rather large disparity. So the registration statistics, not as much. It's still a disparity, but when you get down to those who are convicted of failure to register, the disparity increases quite a bit. And I think putting together those charts to show the differences is important information. Sherry.
Thank you for clarifying the disparity on the failure to register component. And I know that tied into Patty's homeless concern as well. So there was a bit of a cross section on the why. And I think, you know, one of the topics that we haven't spent a lot of time on is we have last time on the failure to register, but ultimately, if there was an opportunity, sometimes I think out of this to create more operational platforms or things that can be done to improve them versus changing statutes. I also think, there are other opportunities that this group has raised, whether that was QR codes, advocates at the sheriff's offices, things of that nature. Mark, how do we best, because I continue to be in the camp that failure to register is, we saw the leap. I understand why you might not, but I don't think that, because failure to register may be difficult, it means it shouldn't be there. And I think I think there's a reason that it's there. That said, I'm, a very small voice here. At the same time, are there things that we can do and impact from this group that aren't legislative in any way? Things that provide us access points for either homeless rules or access points for each sheriff's office relative to the dates and times, because I know we talked about them being weekday. Are there extension of hours? Is there QR codes that can be put in places? So we begin to remove shame and access is opened versus limited. And I don't know how the group feels about that, but there are things, in many cases that already exist. And I think if we have all of this legislation and law for a reason, then giving people more channels for compliance perhaps is an opportunity for this group versus removing the requirement to begin with. So it's just one person's perspective, but operationalizing it seems to be a little bit more of a challenge.
Any other discussion, comments on this or other areas? Angie.
So sorry that I missed the first part of the meeting. I had to go to court this morning, but I'm wondering, did you guys talk about the lifetime requirement at all? And is that something that this group wants to talk about? I know at one point I had was working with Brian a little bit to see if he had any information that might be helpful on those requirements. And then he wanted more time, and I just don't know if, does this group want to address that requirement, or I don't know, Representative O'Neill, if you think that is something that's even anyone would be anything that would go anywhere if maybe some of the lifetime requirements were changed.
Well, I think some of those issues that have come up with the lifetime requirement are especially for those out of state, where I think we even had a visitor talk about that, where they would be a 10-year registrant in Minnesota, but because we're adopting the registration period in the other state, that seems to be, at least in some people's view, a bit skewed.
Mark, can I add something on that, please?
Yep.
Oh,
So
yeah,
I'd
go
like to
ahead.
speak to that part just because I was here back in 1999 and in the days of offender shopping states. So
That's what I was gonna
if we
say.
don't adopt we only look at the state of conviction, and I explained it to the group when I presented back at one of the first couple of meetings, in that we have offenders that move from state to state to state. They could adopt a lifetime somewhere along the way. We don't take that. We always go back to the state of conviction. But if we undo that and give them less time than what that state of conviction is, we become the state where the offenders may come to. And I know along the way, people were asking about, well, what if that state of conviction changes their registration period and gives them, 5-year, or if they give them 15 instead of lifetime? Minnesota is a minimum of 10 years. So we would say that 5-year person would still have to register for 10 here. But if they're lifetime and they petition in that other state of conviction and it drops, we would follow that. But I just want to make sure that the group knows that by undoing lifetime, because we'd only give them 10 in Minnesota, but their state of conviction is lifetime. We got to be careful on that. I just wanted to make everyone aware.
Yeah, that's what I was gonna say. My recollection, I was around too when that change went through, and my recollection was that it was to avoid forum shopping, and they didn't want people saying, oh, I have to register for less there, so I'm gonna go there. So for what that's worth, that's what I think it was. But the stuff I was talking about with Brian was more the specific, not the out of state, but our specific list of lifetime offenses and the sub paragraphs. And you know how like there are some offenses that require lifetime registration for one conviction. And I was just wondering if that was anything. What I had asked Brian was whether he knew of things in the research as far as risk is concerned that would make those things maybe worthy of that lifetime on the first offense or not. So I was just curious. I just thought this group might be interested to know that. And I don't know if Brian was, if there's ever even anything you can find out as far as that goes.
So just speaking on that topic, yeah, just in-state only, if we're just talking, like Angie said, lifetime registrants, first-time offenses in Minnesota based on the statutory conviction. I guess part of what Angie and I were talking about too is the history behind that and why those certain statutes became lifetime registration eligible. There was some discussion about CSC 1 involving penetration of a 13, somebody less than 13 years old, force involved in the offense, some of those things. And again, we get into looking at each individual person in some of these situations is necessary because the level of intrusiveness of a crime is not necessarily related to risk for recidivism. Actually, non-contact offending, indecent exposure, voyeurism, some of those paraphilic behaviors, the likelihood of reoffending in those respects is much higher than somebody committing a contact penetrative offense. So just the fact that somebody, we see a lot of guys engage in penetration of victims under age 13 doesn't necessarily increase their risk for committing future sex offenses. Now, looking at given individuals in that group, does somebody have pedophilic interests? That would increase their risk, as opposed to somebody who didn't. The level of force involved in an offense. Sometimes we use the individual uses what's we call instrumental violence. So enough to complete the sexual act. It could be a violent offense using force involving assaultive behavior. That doesn't necessarily increase their risk. Now, that same person, if they were diagnosed with sexual sadism, that is somebody who is sexually aroused to committing violence against somebody. That person would be at higher risk. So, kind of what Nate had said just about breaking down motivation and really looking at individual factors is what's needed in a lot of these cases, but the process for doing so and resources and all those things is difficult. And so I understand what Andrew said before about needing some strict sort of statutory criteria to make those decisions as well. So anyways, just a little blip overview there of some of the stuff I looked into. But does anybody know the history kind of behind why those certain statutes became lifetime registration eligible? That will be helpful. And then also, I don't think we have the data, and I think BC maybe said they couldn't pull it. The numbers that are currently lifetime registrants based only on the one offense, not the reoffense situations, but that would be helpful to know as well. Yeah, I'm guessing that those were picked because they were deemed more serious offenses, because anytime you're engaging in penetration with someone under 13, that's going to be deemed a serious, more serious. And same with kind of the force and those things. That seems logical that's why those were singled out. Katie, do you know, or Olivia, kind of what the breakdown is for lifetime as far as first time offenses versus repeat offenders?
No, we just see lifetime is my understanding. I mean, we can give you the head counts on lifetime, but not necessarily the breakout.
Couldn't you, and again, this is an IT question, but couldn't they search by the statutes of conviction? Or would that not separate out the single versus double? You know what I mean? Like the statutes that require lifetime, could they search those to find out what percentage they are?
Okay. So the problem with trying to figure out someone's end date reason is if you have an offender who has too to many registrations, we don't have one end date reason. The first offense could be a 10-year registration period, and we can't see down to that one, the ultimate end date reason on that. So this is where we struggle again. We're asked to hold data and store those things in subdivision 4, whatever it is. And so to drill down and show this, I'm not certain that we can do it. We can look at it and see, but I feel like it was asked before and I'm not sure if it can be provided.
Well, and an interesting part of the lifetime registration is also that, and I think Brian can talk about this issue too, is that those who are convicted of these offenses sometimes have a number of offenses in the past. So they may be charged with 2 different offenses, and the disposition may be on different dates. And that, I believe I'm correct on this, Katie, is if the disposition is on one case is one day and then the other is a month later, but they all occurred before the person was arrested, that is a repeat offense and ends up as a lifetime registration.
Yeah, as long as the court files are convicted on separate days, then it constitutes a prior. 2 convictions or 2 sentencings held the same day does not constitute a prior. Angie has case law that came out on that.
Yep.
So if we're just talking from a risk perspective there, so the concept Mark's describing is what we call pseudo recidivism. So let's say somebody commits a number of offenses between 2005 and 2010, and then one victim comes forward in 2011, and that is going through the criminal justice system. Another victim comes forward and says from 2006 to 2009, so-and-so offended against me, 2011, more charges are brought. So it's really the first interventions that has happened with this person, but then they get multiple convictions for behavior that was undetected until the initial victim came forward. That person's going to be really the bigger concern is people that commit offenses after initial detection. So the true repeat or recidivistic offender would be somebody who's caught, detected, goes through a criminal justice system, treatment, whatever it is, and then goes on to reoffend. Those folks in general are higher risk on actuarial instruments, and as opposed to somebody who committed a number of offenses, is caught, maybe a few of those come forward, there's multiple convictions, and then does not go on to reoffend after that. So that's the concept we're describing here. So I guess the lifetime can be given based on those separate convictions, even though the offense behavior happened at the same time period prior to any intervention.
And that can happen with even the juvenile registrants end up on lifetime registration because they had 2 different victims and the disposition of those cases was separated.
I think you have to be careful on using the term 2 different victims, Mark, and that 2 different cases, not 2 different victims, because you and I are used to seeing these, and they can list multiple victims in one court file.
Yeah.
And that would be one case. So 2 separate cases.
Yeah, Yeah, exactly.
Would, just real quick, I don't know if this would qualify too, but if somebody offended against the same victim, Katie, maybe you could speak to this too. I just saw a case in 2 separate counties, offending behavior crossed county lines, but it happened during the same 5-year period, and they were convicted in both counties. Is that person subject to lifetime registration as a recidivistic offender as well?
If they didn't put the 2 cases together, yes.
Okay.
You know,
All
and if they weren't sentenced on the same day, I mean, we often see how they move those to the county where the juvenile's living or something. I don't know, you'll see that happen, but as long as those 2 court files are, you know, the conviction comes on separate days, they're sentenced on separate days or adjudicated, whatever, then registration would be lifetime as long as that offense was committed after August 1st of 2000.
Okay, and yeah, and I wasn't even specifying juveniles in that case. This person I'm thinking of was an adult, but both ways, that's helpful information. Thanks.
Yep.
Any other areas? Issues, coverage?
So Mark, the language that you shared today, was that the initial language or was it after Chris and Stacy had amended it on my proposed on the language that I came up with to address the extensions?
It could have been initial. I don't know if.
Because Chris did a nice job kind of breaking that language up some, and I think Stacy messed with it a little too. So I don't mean messed in a bad way. I think she made some amendments too. So we can send at least the most recent version over for you to distribute to the group if that would be helpful.
Yeah.
And then I think, yeah, I mean, I guess we can discuss whether it makes sense to add more, you know, offenses, but still limit it to not all offenses.
Yeah, and I think that was what the discussion was perhaps the need to add additional ones.
I had done the crimes against the person from 243-167, but I had taken out the possession of firearms offenses that we talked about.
Yep.
And then I had added terroristic threats, and the statutes I could find on violation of like no contact orders or OFPs. I think there were like 4 different ones I added that dealt with that. And that's all I added just because that was based on the discussions we had, the ones that we had talked about adding.
I was just going to add, Angie, that I think you missed too, that Sheriff Hack had talked about adding, yeah, so maybe more for some of the chairs, additional discussion, but talked about arson or second-degree burglary, you know, and unoccupied residence, but really Nate and some people brought up like I mentioned before, the motivation behind each of these crimes is really what is important. And I know it's difficult to, from a resource standpoint, do that on each individual case, but I said second-degree burglary I've seen as a fetish burglary. Somebody steals underwear for masturbatory purposes, paraphilic behavior, but oftentimes it's just not just, but breaking into somebody's home and stealing items to pawn for drug purchase or that kind of thing too. So, but additional crimes being added was something that needed to be further discussed for sure.
Okay. That's all I've got.
Okay. I guess if there are any comments from the public, you can raise your hand at this time, just to make sure that we get the opportunity in for you. Ashley.
Hello, good morning. I'm Ashley Stewarts Griffith, and I'm from Mincasa. I know I've been showing up a lot of these meetings, so maybe you know who I am already. I guess I just wanted to kind of highlight or maybe impress that I would agree with Angie in terms of putting decision-making power in the hands of the judges. I mean, of course, I know that they have some already, but I guess in my experience, kind of on the other side as a victim advocate, I know there are some pretty dangerous judges. And of course, judges as humans, you know, have their own, I think, like racial bias. And just like, I think there are a lot of issues in terms of equity there too. I know just like as a victim advocate, you know, whichever judge you got would like make or break case. So I just think that there would be a lot of issues of equity around that. So I would just encourage to have a little bit more like straightforward process for that and not putting in the hands of individuals to make that. So that's all I wanted to say, but thank you all for your work on this group.
Since we have plenty of time here, I wanted to go to Sherry here. If you had a comment at this point.
Yeah, I thank you for your comments just there. I do think, you know, for a people business, we tend to not want to put decision-making in people's hands for all of these interesting reasons. And I do understand your comments. So they're good. I think as we were talking about it, I think the notion of the right of first impact is if you're convicted of the crime, it is there. In circumstances where I think, you know, that keeps the list broader, there are some benefits to further evaluation. And if a judge did not rule on it, I guess the question would be, my assumption would be then it would trigger, they would rule not to versus rule to, I think. And so there's also, and I don't know how all of that works. And I think it's just the question around administratively, Ashley, not seeing what happened or having a subjective, which it is subjective to Brian's point, I think, in terms of the intent. I do see your point. My guess would be the way I thought about it was as it was, unless otherwise per se, there was some specific reason that you could say, man, this did not, you know, and that's not for crimes against a person. That's just for the other thing. So I'm with you. And I think you try to look at what yields the most unbiased and predictive for making these decisions. So I think your commentary is good. So I just want to thank you for that.
You know, another idea, this is just totally random. I'm thinking of this right this second, so I don't know how practical it would be, but another possibility would be to use the list and then maybe other like felony offenses, or, you know, like maybe find some way to get rid of like the misdemeanor disorderly conduct. You know what I mean? Like,
yeah.
So use the list, or maybe, you know, any felony conviction, or instead of separating out certain crimes, or anything under the list at any level, and then felonies for any other crimes or something like that, if we want to add but not include things like the disorderly conduct. So that's just an idea. I don't know, we'd have to look at language for that.
Can I comment on that, Mark?
Sure.
Yeah, sorry. That's exactly, Angela, before you came on, that's what was being said. Like, do we go with what isn't versus what is? And that was exactly the point. Do we go back and go over it again with Sheriff Heck's comments, just as you stated? That was exactly the point right before you came back from the morning.
Okay, Mary.
Good morning. I'm Mary Cardinal Peterson, and I'm currently serving as chair of the MCA Legislative Committee. And I just wanted to comment on the discussion about the lifetime registration for first-time people convicted of criminal sexual conduct in the first degree, that while I agree that those that because of victims being under 13 years old, we do have people convicted that are victimizing and abusing children that are not related to them, and that is highly dangerous. In my time working as a probation and parole officer and as a therapist and release planner for the Department of Corrections, working in the sex offender treatment program, the majority of the first time criminal sexual conduct first degree people that I worked with were intrafamilial cases where it's both juvenile and adults convicted under that statute for the first time and are subject to lifetime registration. And that's where that statute and that lifetime requirement is a little more harder to see working, because historically intrafamilial cases are the people who respond best to treatment and have a low recidivism rate, which is something that Brian could speak more to, but I hope that that is considered in looking and drafting language and changes. Thank you.
Katie, aren't there some exemptions for juveniles on those first offenses?
Yep, so I was just gonna speak to that. Hi, Mary, by the way. With the juveniles, that has to be a repeat. Those first time offenses are applied to adults only on a first time conviction. So no juvenile, with the exception of 609.185 clause 2, which is that murder, first degree murder while committing a sex crime. That's the one way, or civil commitment as sexually dangerous or sexually psychopathic would also get a juvenile lifetime registration. Otherwise, one offense applies only to adults.
Okay, any other questions, comments? Anything final, Olivia?
No, see you guys in a couple hours here.
And Angie?
We'll just talk about if we're going to do another meeting next Monday, and well, I don't have anything else.
Yep. Okay.
Thanks, everyone.
Thank you.